Some daughters are described by the people who raised them as sweet, obedient, the kind of girl who sings in the church choir on Sunday morning and sits quietly at the dinner table while her parents talk about her future. The kind of girl whose bedroom walls hold trophies and ribbons and school photographs. The kind of girl nobody suspects. But behind that image, 10 separate cases across 3 countries. Something else was building. A plan, a phone call, a weapon loaded in the dark, a boyfriend recruited, budget drawn up in text messages, on a phone that would later be recovered by investigators. Each of the daughters in this video made a calculated decision that the people standing between them and what they wanted had to go. Some pulled the trigger themselves. Some waited outside while others did the work. Some sat down afterward and sent text messages from their mother's phone. All of them believed they would walk away clean. None of them did. Today we are covering 10 daughters who thought they would get away with murder. Case 1, Carly Madison Gregg. The afternoon of March 19, 2024 began like most Tuesday afternoons in Brandon, Mississippi. School buses made their rounds through the quiet residential streets of Rankin County. Kids came home, dropped their bags by the door, and settled into whatever version of after-school routine their households ran on. In the Smiley home on Castlewoods Drive, Ashley Smiley had beaten her daughter home that day. She was 40 years old, math teacher at Brandon High School, the same school her daughter attended. She had come home early, and she had started looking. Ashley Smiley was, by every account, a woman who had built her life around young people. She spent her days in a classroom teaching mathematics, working with teenagers who ranged from engaged to indifferent, giving her time to a profession that asked a great deal and returned it in less tangible ways. Her daughter, Carly, 14 years old at the time, was one of those teenagers, navigating the same hallways where her mother taught. Carly was small, with a round face and a manner that the people around her tended to describe as quiet. Her stepfather, Heath Smiley, 39, described her in court as a sweet little girl. From the outside, the Smiley home in Rankin County looked like what it was supposed to be: family in a comfortable neighborhood in a quiet part of Mississippi. What Ashley had discovered that afternoon was not consistent with that image. A friend of Carly's had already contacted Ashley earlier in the day. The friend had information about Carly's drug use, about a life the teenager had been running in parallel to the one she showed her family. When Ashley got home, she searched. What she found, according to the details that came out at trial, included burner phones and evidence of marijuana use. The kind of material a 14-year-old hides, because she understands with precision that the people who love her would not accept it. Whatever Ashley found that afternoon, it was enough that she was still at home with it when Carly walked in from school. Smiley home had a security camera system. It was active on the afternoon of March 19. Footage it captured was played for the jury over the course of 5 days at trial in Rankin County Circuit Court, and it became the center of everything. In the footage, Carly can be seen moving through the kitchen. She is holding something behind her back. The object is a .357 Magnum revolver, her mother's handgun, which she had retrieved from somewhere in the house. She moves through the frame with deliberate steps, her body angled to keep the weapon out of sight of the camera. She disappears from view in the direction of her mother's bedroom. 3 shots ring out. She comes back into the kitchen. Approximately 10 seconds later, the weapon still held behind her back, she walks to the counter and picks up her mother's phone. She sits down on a kitchen stool. Her 2 dogs come to stand beside her. She starts typing. Ashley Smiley had been shot 3 times in the face. She did not survive. The messages Carly sent from her mother's phone were addressed to Heath Smiley. They were casual and warm, The kind of texts that pass between a wife and husband in the middle of an ordinary afternoon, asking when he would be home. Heath received them and read nothing unusual into them. He came home. When he opened the front door, Carly was waiting. She fired once. Bullet struck Heath in the shoulder. He managed to get the weapon away from her. Carly ran through the house, out the back door of the yard fence, and disappeared into the neighborhood. The Mississippi Highway Patrol helicopter located her not far from the property, less than an hour after Heath's 911 call. What investigators found inside the house was documented thoroughly. Ashley Smiley was in Carly's bedroom, lying on her back, a bloody towel placed over her face. Forensic analysis recovered one projectile from her brain and another from her neck. The ballistics matched the .357 Magnum recovered from the scene. Carly's hands tested positive for gunshot residue. Her stepfather, shot in the shoulder, and present at the scene, gave investigators a coherent account of what had happened when he arrived home, also a statement. After her arrest, Carly made a remark that the state prosecutor, Catherine White Newman, would later reenact in closing arguments for the jury. Carly had told investigators, "Put 3 in my mom, and I got 3 more waiting for my stepdad." Newman stood in the courtroom and asked the jury whether that sounded like the statement of someone experiencing a mental health crisis, or the statement of someone who had known exactly what she was doing. Carly Gregg was charged with first-degree murder, attempted murder, and tampering with evidence. Rankin County Circuit Court Judge Dewey Arthur presided. The case was tried in adult court. Carly's defense team, led by attorneys Kevin Camp and Bridget Todd, entered a plea of not guilty by reason of insanity, post. Their argument to the jury was that Carly did not understand what was happening at the time of the shooting. She was in a state of mental health crisis that prevented her from forming the intent required for first-degree murder. Prosecution responded with the surveillance footage, with the forensic evidence, the text messages sent from her mother's phone to lure her stepfather into the house, with the gunshot residue, with the statement she had made after her arrest. The jury deliberated for 2 hours. On September 20, 2024, Carly Madison Gregg was found guilty on all charges. Judge Arthur sentenced her to life in prison without the possibility of parole for the first-degree murder conviction, with a concurrent 10-year sentence for tampering with evidence. She was 15 years old at sentencing. Rankin County District Attorney Bubba Bramlett addressed the media outside the courthouse and said that sometimes evil comes in young packages, and that this was one of those cases. He said she was exactly where she belonged. Carly's defense filed a motion for a new trial shortly after the verdict, citing newly discovered evidence and arguing procedural irregularities in the original proceedings. Judge Arthur denied that motion. Defense attorney Bridget Todd filed a notice of appeal to the Mississippi Supreme Court in October 2024. As of the time of this video, appeal remains active and Carly Gregg remains incarcerated. The people who knew Ashley Smiley described a woman who had given her professional life to young people and who had spent the afternoon of March 19 doing exactly what a parent does when something feels wrong. She was looking and she found something, and the finding of it cost her everything. She was 40 years old. Heath Smiley survived a gunshot wound to the shoulder. He testified at trial and described Carly in the years before March 2024 as a sweet little girl. He is alive today. Trial drew substantial national attention, in part because of the surveillance footage, and in part because of Carly's age. A 14-year-old who shot her mother 3 times, and then sat down with the dogs and sent text messages from the dead woman's phone To bring her stepfather home is not a case that fits neatly into any existing framework. The jury took 2 hours. The judge said she belonged in prison for the rest of her life. The Mississippi Supreme Court is still looking at the appeal. The surveillance footage captured in those 10 seconds between the shots and the moment Carly reappeared in the kitchen is the part of this case that has stayed with everyone who watched it. The stillness of it. The deliberate act of sitting down, the phone, the dogs, the typing. Whatever was in that bedroom, she did not go back. Ashley Smiley taught math at Brandon High School. She came home early on a Tuesday afternoon to check on her daughter and died in that daughter's bedroom with a towel laid over her face. She was 40 years old. Her daughter is serving life without parole in a Mississippi correctional facility. Heath Smiley's shoulder healed. Rest of it has not. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next case also begins with a teenage daughter who decided her parents were the problem. But where Carly Gregg pulled the trigger herself, the girl in the next case had a different approach. She drew up a budget, she made calls, she recruited people, and on the night it happened, she stood outside the house and waited while the work was done. Case 2, Dahlia Bolin. On the evening of October 22, 2021, deputies from the Tazewell County Sheriff's Department responded to a shots-fired call at a rural property outside Mackinac, Illinois, a small agricultural town of roughly 1,500 people located 15 miles south of Peoria. The call had come in at approximately 9:15 in the evening. When the first deputies pulled into the driveway, a teenage girl was standing outside the house. She was calm. She told them someone had broken in and shot her parents. It was a robbery, she said. She did not know who was responsible. She had no idea what had happened. Her name was Dahlia Bolin. She was 15 years old. Inside the house, deputies found Rebecca Bolin, 51 years old, shot multiple times. She did not survive. Her husband Douglas Bolin, 52, had also been shot and was in critical condition. He was transported by emergency services to a trauma center. He would survive. The recovery from multiple gunshot wounds would take considerable time. The house was not ransacked. Nothing appeared to have been taken. There was no sign of forced entry, consistent with a break-in from an unknown party. The scene did not look like a robbery in any detail that mattered. Bolin family had lived in the Mackinac area for years. Douglas and Rebecca ran their household with the ordinary rhythms of rural Midwestern family life. Douglas Bolin was a working man with a personal collection of firearms kept in the home. Rebecca Bolin was his wife of many years and the mother of their daughter. Dahlia attended school in the area and by all outward appearances was a teenager navigating the usual landscape of adolescence in a small Illinois town. The investigation that followed the October 22 shooting would dismantle that appearance entirely. The digital record that Tazewell County investigators began pulling together in the days after the shooting was extensive. Phone records, text message histories, and communications across multiple platforms between Dahlia and a group of acquaintances told a story that bore no resemblance to the account she had given deputies on the driveway. The shooting had not been a robbery. It had been planned. Dahlia Bolin had been the one doing the planning. She had recruited 3 people. The first was her boyfriend, Nathaniel Maloney, 19 years old, Morton, Illinois. The second was Andre Street, 18, of Groveland. The third was Sage Reiber, 21, of Morton. The arrangement, prosecutors laid it out, was direct. Maloney and Street would enter the Bolin family home and shoot both parents. In exchange, Dahlia had promised each of them a share of $100,000 to be drawn from the life insurance policies her parents carried. She had also promised them guns from her father's collection, firearms that Douglas Bolin later confirmed as his own when he identified them as the weapons used in the attack on his family. Rayuba's role was to drive and wait. The planning had not been a spontaneous decision made in the heat of a single argument. The electronic communications established that Dahlia had been working through the details for a period of weeks before October 22. Prosecutors told the court that the original plan, as Dahlia had first conceived it, had targeted only her father. She had initially sought out the group to have Douglas Bolin killed because she was, as the court filings put it, having trouble with him. The scope of the plan later expanded to include her mother as well. No specific reason for why the plan grew to include Rebecca was disclosed at the sentencing hearing. The communications simply showed that at some point before October 22, both parents had become targets. The logistics were organised through electronic devices. The payments were discussed in text. The guns were identified. Maloney and Street drove to the Bolin property twice in the days leading up to the shooting. Once the night before to look at the location, and again on the night of October 22 to carry out what had been agreed. Rayuba waited in the car on the road outside. Dahlia stood outside the house and watched. When it was over and the group had gone, she remained on the property. She was the one who met the responding deputies. She was the one who told them it was a robbery. Rebecca Bolin was shot multiple times inside her own home. She was 51 years old and did not survive the night. Douglas Bolin was also shot multiple times and survived with serious injuries. He was in a trauma centre while his daughter was being interviewed by investigators in the driveway. All 4 participants were arrested within days of the shooting. The digital trail was, as prosecutors described it at the time of charging, comprehensive. Text messages, call logs, platform communications, and the forensic evidence from the scene all pointed in the same direction. Dahlia's account of a robbery collapsed against the weight of what the phones showed. There had been no intruder. There had been a plan, payment structure, and a 15-year-old girl who had organised both. Dahlia Bolin was initially processed as a juvenile. Under Illinois juvenile law at the time, had her case remained in the youth system, proceedings would have been sealed from the public, and her detention would have ended automatically on her 21st birthday, meaning she would have served fewer than 6 years. In April 2023, following a hearing before Tazewell County Juvenile Court Judge David Brown, the case was transferred to adult court. Judge Brown ruled that adult prosecution was appropriate, given the nature and planning of the crime. Transfer mattered in every practical sense. It meant the proceedings were public, meant the sentence would reflect the full weight of the charges. It meant Dahlia Bolin would be sentenced not as a child who had made a terrible decision, but as an adult who had constructed a plan over weeks and paid 3 people to carry it out. On January 16, 2024, 4 defendants appeared before Chief Tazewell County Circuit Judge Chris Doskotch. All 4 pleaded guilty. Dahlia Bolin, then 17, and wearing a pink hoodie, entered the courtroom accompanied by a service dog. She answered the judge's questions when asked and otherwise said little. She pleaded guilty to first-degree murder, attempted first-degree murder, solicitation of murder for hire, and conspiracy to commit murder. Judge Doskotch sentenced her to 60 years in prison. Prosecutors told the court that with credit for the more than 800 days she had already served and applicable good time credits on the non-murder counts, she would likely serve just over 54 years. She would be held in juvenile corrections until she turned 18 in May 2024, at which point she would be transferred to an adult facility. Nathaniel Maloney, who had entered the house and fired, received 66 years. Andre Street received 55 years. Said Reiber, the driver, received 30 years. As part of her plea agreement, Dahlia agreed to testify in any future proceedings connected to the case, including any additional charges that might arise. Douglas Bolin attended the sentencing. He was the man who had survived 5 gunshot wounds fired by people his daughter had recruited and paid with money she had not yet collected from his own life insurance policy. He was also the man whose guns had been used to carry out the attack. He had identified those firearms when asked to do so by investigators. He is alive today. Rebecca Bolin was 51 years old. She was shot in her own home on the evening of October 22, 2021, by people her daughter had contacted, organised, briefed, and promised payment. Dahlia was standing outside when it happened. When the deputies arrived, she told them calmly that she did not know who had done it. The sentencing hearing was attended by more than 100 family members and community members. Tazewell County is a small place. Boland family had roots in the area. The shooting had been local news from the first night and had remained so through every stage of the legal proceedings. The judge spoke. The prosecutor spoke. Dahlia said what she was required to say to complete the plea and received the sentence the agreement specified. She was 17 years old in the courtroom. She will be in her early 70s before she is eligible for release, assuming she serves the full term, and is not granted parole at any earlier point available under Illinois law. The insurance money was never paid out in the way the plan had envisioned. The life insurance policies that Dahlia had cited as the funding source for the $100 feels zeroed she had promised. Her accomplices did not produce the windfall she had outlined in those text messages. The plan had a budget that rested on the assumption that the killing would look like something else, and that the money would follow. Neither assumption held. What the phones showed when investigators pulled them was a 15-year-old girl who had thought carefully about the logistics of having her parents shot, and had written a significant amount of that thinking down in text messages on devices she did not destroy. The Tazewell County Prosecutor's Office described the digital evidence as among the most comprehensive they had assembled in a case of this kind. The evidence did not require a confession. It did not depend on the co-defendants turning on each other. It was in the messages. Dahlia Bolin is currently serving her sentence. Rebecca Bolin is buried in Tazewell County. Douglas Bolin is alive and has spoken to media at various points in the proceedings. The house outside Mackinac, where it happened, is still there. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next case takes us out of the American Midwest entirely and across the Pacific to a 5-star resort on the Indonesian island of Bali, where an 18-year-old girl from suburban Chicago sat in a hotel room with her mother and her boyfriend and made a decision that would take 2 countries, 2 separate legal systems, and nearly a decade to fully resolve. Case 3, Heather Mack. The morning of August 12, 2014 started the way mornings start at 5-star resorts. Staff moved through the corridors with practiced efficiency. Guests ordered room service and sat on balconies that looked out over the Indian Ocean. The St. Regis Bali Resort on the southern tip of the Indonesian island was exactly the kind of place that insulated its visitors from the ordinary friction, the world outside its gates. Private villas, butler service, a beach that had been curated as carefully as everything else on the property. It was the kind of place you travelled a long way to reach, and the kind of place where nothing was supposed to go wrong. A suitcase was found in the trunk of a taxi parked near the hotel entrance. The suitcase was not large enough for what had been put inside it. When staff and then security opened it, they found the body of Sheila von Wiesemak, 62 years old, wealthy Chicago socialite and academic, who had travelled to Bali for a holiday with her daughter and her daughter's boyfriend. She had been beaten to death. The case, her body folded into it, had been loaded into a taxi and left outside the entrance of the resort where she had been staying. What followed was an investigation that crossed 2 countries, 2 legal systems, decade of proceedings that did not fully resolve until January 2024. Sheila von Wiesemak had built a life that carried considerable weight in Chicago's upper social circles. She had been educated, well-travelled, financially secure. Her late husband had left her in a position of comfort. She had continued to cultivate the kind of life that moves between good addresses and good company. She was 62 years old in the summer of 2014, recently widowed, and she had decided to take her daughter to Bali. The decision to bring the daughter's boyfriend along as well is a detail that received considerable attention during subsequent legal proceedings. Given what the relationship between the 3 of them looked like by the time they arrived at the St. Regis. Her daughter was Heather Mack. Heather was 18 years old in August 2014, living with her mother in the affluent Chicago suburb of Oak Park. The relationship between the 2 of them had been, by any available measure, deeply unstable for years. Police had been called to the family home in Oak Park more than 40 times over the course of Heather's adolescence. The calls documented a household in sustained conflict. Heather had grown up in the shadow of money she did not yet control and under the authority of a mother she had spent years fighting. By 2014, she was an adult in the technical sense, but still financially dependent on Sheila, still living in Sheila's house, and still locked in the same dynamic that had defined their relationship since Heather's childhood. Boyfriend was Tommy Schaefer, 21 years old. Heather and Tommy had been together for some time before the Bali trip. Tommy was not a figure who moved in the same social world as Sheila von Wiesemak. The friction between Sheila and the relationship her daughter had chosen, Chosen, was documented in the background of the case. What brought the 3 of them to Bali together? Given all of that, was never entirely explained in a way that satisfied outside observers. What happened once they arrived is what the Indonesian court and later the American federal court both had to determine. Security footage from the St. Regis captured an argument in one of the hotel's public areas. The 3 of them were visible on the recording, the dispute appearing to centre on a bill. The argument was witnessed. It did not resolve cleanly. What happened in the hours after that argument, inside the hotel room the group shared, was reconstructed through physical evidence, forensic analysis, and the accounts given by Heather and Tommy across multiple rounds of questioning and legal proceedings that stretched across several years. The Indonesian prosecution's account, which was ultimately accepted by the court, was the following. At some point during the evening, after the argument that had been captured on the hotel's security system, Tommy Schaefer struck Sheila von Wiesemak repeatedly in the head with a metal fruit bowl. He did this while Heather held her mother's mouth closed to prevent her from making noise. Sheila von Wiesemak died from the injuries she sustained during that attack. She was 62 years old and had travelled to one of the most expensive resorts on an Indonesian island with her daughter and her daughter's boyfriend. She did not leave that room alive. After the beating, the 2 of them faced the problem of what to do with a body in a hotel room. The solution they arrived at was to fold Sheila into a suitcase. The suitcase was not big enough to hold an adult woman without considerable effort. Photographs of the suitcase that later circulated through global media coverage became one of the defining images of the case. The dimensions of the bag set against the investigators said had been placed inside it. The suitcase was then loaded into a taxi and left in the trunk outside the hotel entrance. It was found by staff on the morning of August 12. Indonesian authorities arrested Heather and Tommy within days. The investigation was not complicated by any shortage of evidence. The hotel's security footage documented the argument. The forensic evidence in the room documented what had followed. The suitcase was physical fact. Heather was 18 years old at the time of her arrest. She was also, as it emerged in the weeks after, several weeks pregnant. She gave birth to a daughter while in Indonesian custody. The baby, named Stella Schaefer, was born in 2015. Heather and Tommy were both tried in Bali's district court in Denpasar. The Indonesian proceedings attracted international attention from the moment the arrest photographs were published. An American teenager, pregnant, in an Indonesian jail, facing a murder charge connected to her mother's body, found in a suitcase at a luxury resort. The case moved through a global news cycle with the specific momentum that attaches to stories that contain this particular combination of wealth, youth, violence, and tropical geography. The Indonesian court convicted Tommy Schaefer of murder and sentenced him to 18 years in prison. He remained incarcerated in Indonesia. Heather was convicted as an accessory to murder. The Indonesian court imposed a sentence of 10 years. Toast. She was 19 years old at the time of sentencing, sitting in court with her infant daughter, and the Indonesian prison where she would serve her time was not the St. Regis Bali resort. She served 7 years of the 10-year sentence. Indonesian prison authorities awarded her a total of 34 months in sentence reductions for good behaviour, granted incrementally across major Indonesian national holidays over the course of her incarceration, including a 6-month remission awarded during Indonesia's Independence Day observances in August 2021. On October 29, 2021, Heather Mack was released from Kerobokan Female Prison in Denpasar. She said nothing to the crowd of reporters who had gathered to document her exit. She was escorted to an immigration facility near Bali's international airport and deported to the United States. She did not land as a free woman. Federal prosecutors in Chicago had been tracking the case throughout Heather's Indonesian incarceration. The legal argument they had constructed rested on a specific feature of American federal law. The conspiracy to kill a United States citizen in a foreign country is a separate federal offence from the Indonesian charges. Prosecution of that offence does not constitute double jeopardy because it addresses a distinct criminal act under a distinct legal framework. When Heather's flight landed at Chicago's O'Hare International Airport, FBI agents were waiting. She was arrested at the gate and charged with conspiracy to kill a United States citizen abroad and obstruction of justice. The federal charge carried a maximum sentence of life in prison. Heather's initial response was to plead not guilty. Trial was scheduled for August 1, 2023. The case had been moving through the federal system since her 2021 arrest, accumulating the procedural weight of a serious federal prosecution while Heather remained in custody in Chicago awaiting resolution. In June 2023, Attorney announced she intended to change her plea. On June 2, 2023, Heather Mack appeared before U.S. District Judge Matthew Kennelly in Chicago Federal Court. She was 27 years old, dressed in orange jail clothing and orange slippers. Judge Kennelly asked questions. She answered each one with clarity and composure. When the judge asked whether she understood she was giving up her right to remain silent, she said, "Yes, Your Honor." She then pleaded guilty to 1 count of conspiracy to kill a United States national. The change of plea hearing was brief. Sentencing was scheduled for December 2023 and later moved to January 2024. There was also a background financial dimensions to the case that had been running in Chicago's civil courts throughout the entire criminal proceedings. Sheila von Wiesemak had established a trust fund for Heather, funded by the estate of Heather's late father, who had died in 2006. Trust was valued at approximately $1.5 million at the time of Sheila's death. Heather was the named beneficiary. Cousin of Tommy Schaefer's, named Robert Bibbs, had pleaded guilty in 2016 in a Chicago federal court to helping plan the killing of Sheila von Wieser Mack in exchange for a promised payment of $50,000 from that trust. The trust became the subject of contested civil litigation in Chicago's courts that ran parallel to the criminal case for years. Heather, from her Indonesian cell, wrote letters to a judge in the civil proceedings, arguing that her mother had been attempting to manipulate the trust documents before her death. The civil dispute over the trust, and who had legal access to it, remained unresolved for an extended period. On January 17, 2024, Heather Mack appeared before Judge Kennelly for sentencing. The courtroom in Chicago was a long way from the St. Regis Bali resort. Judge Kennelly addressed her directly. He described the crime as brutal and premeditated. He noted that the world had known from the beginning that justice had not been fully served by the Indonesian proceedings, and that the sentence he was about to impose was the American legal system's answer to that gap. He also confirmed that Heather would not receive credit toward her federal sentence for the 7 years she had served in Indonesia. The federal sentence would begin from the point of her American custody. He sentenced her to 26 years in federal prison. Her attorney, Michael Leonard, spoke to reporters outside the courthouse and offered a calculation he believed was more practical than the raw number. He expected Heather, counting for federal good behavior credits available to all federal prisoners, and the approximately 2.5 years she had already spent in American custody following her 2021 arrest, to serve roughly 20 years before release. Under that calculation, she would be in her mid-40s when she left federal prison, assuming no violations and no complications. Tommy Schaefer remained in an Indonesian prison as of the time of this video, serving the 18-year sentence imposed by the Bali District Court. He had also been named in the American federal indictment, but the question of whether he would ever face American prosecution remained subject to his Indonesian incarceration and the diplomatic arrangements between the two countries. Stella Schaefer, the daughter Heather gave birth to in 2015 while in Indonesian custody, was placed in the care of an Australian woman during Heather's incarceration. The child was approximately 6 years old when her mother was deported to the United States and rearrested at the airport. The arrangements for Stella's care and custody during the period of Heather's federal sentence were not disclosed in the public court record. There is a particular detail about this case that sat with investigators and journalists and members of the public who followed it across the years, its legal proceedings, the suitcase, not its contents, which were already beyond the reach of anything that could be undone, but its dimensions. Photographs that circulated in the early days of the case showed a piece of luggage that was not large. It was the kind of bag people check for a week's holiday. The fact that 2 people had looked at that bag and looked at the problem they had created and decided it was adequate to the task was the detail that made the case feel like something other than ordinary crime reporting. It was a decision made in a hotel room on a resort island with an ocean view and a butler on call, and it did not reflect any of those surroundings in its mechanics. Sheila von Wiesemak was 62 years old. She had been educated and well-travelled and financially secure. she had decided to take her daughter on a holiday to Bali. She ended up folded into a suitcase in the trunk of a taxi outside the hotel where she had been staying, discovered by staff. On a Tuesday morning, while the rest of the resort guests were having breakfast on their balconies, daughter was 18 years old and several weeks pregnant, and had held her mouth closed while the beating happened. The federal judge who sentenced her daughter a decade later called it brutal and premeditated, and said, "The world had known from the beginning that justice had not been fully served. It had taken 10 years, 2 countries, 2 separate legal proceedings, federal conviction to get to the 26-year sentence handed down in a Chicago courtroom in January 2024. By that point, Stella Schaefer was 9 years old and had spent her entire life in the custody of other people, while her parents were incarcerated on opposite sides of the world. Sheila von Wiesemak has a grave in Chicago. Her daughter is in a federal prison. Granddaughter is 9 years old and has never known anything different. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next case takes us back to the United States and to a Tuesday morning in rural Idaho, where a 16-year-old girl put on a bathrobe backward, pulled a shower cap over her hair, and walked across the property to borrow a rifle from the tenant's room. What she did next would take 5 weeks of live national television coverage to fully lay out for a jury. Case 4, Sarah Marie Johnson, September 2, 2003, was a Tuesday. The town of Bellevue, Idaho, sits at the southern edge of the Wood River Valley, a stretch of central Idaho terrain that runs between mountain ranges and opens up into the kind of landscape that draws people who want to be somewhere beautiful and mostly left alone. Sun Valley, one of the most recognized ski resorts in the American West, sits a few miles north. Bellevue exists in Sun Valley's economic shadow, a working town where the people who maintain the infrastructure of a resort community actually live. It is not a wealthy town, though it sits close to wealth. The Johnson family lived there in a house that reflected the life Alan and Diane Johnson had built together over the course of their marriage. Diane Johnson was 52 years old in September 2003. She worked as a tax collector for Blaine County, a government job that required precision and reliability, and that she had held with both. Alan Johnson was 46 years old, a landscaper who worked with his hands and kept the rhythms of a man whose days were organized around physical labor and the particular satisfaction that comes from work that produces visible results. They had 2 children. Their older son, Matthew, was away at the University of Idaho in Moscow, about a day's drive north. Their younger child was their daughter, Sarah, 16 years old, attending Wood River High School in the nearby city of Haley. By the accounts of people who knew the family in Bellevue, the Johnsons were a stable household. They provided well for their children, present in the community, in the way that families who have been somewhere long enough tend to be. The trouble had a name. By 2003, Sarah had become involved with a 19-year-old man named Bruno Santos. Santos was a high school dropout. He was known in the area as someone with suspected connections to gang activity and drug use. He carried himself, by the accounts of people who described him to investigators and to the press, with the kind of confident indifference to authority that tends to appeal to teenagers who are finding their limits, and adults who recognize the pattern and respond to it with concern. Alan and Diane Johnson were in the second group. They told Sarah the relationship was not acceptable. They told her it needed to end. They were her parents, and this was their house, and the answer was no. Sarah heard a different answer. What happened on the morning of September 2, 2003 was reconstructed over the course of a 5-week trial that would be broadcast live on court TV and watched by people across the United States who had never heard of Bellevue, Idaho, before the case made the national news. The reconstruction rested on forensic evidence, on the physical state of the crime scene, on the testimony of neighbours and investigators and forensic specialists, and on the specific details that Sarah's own behaviour in the hours surrounding the killings had left behind. In the early morning hours before dawn, while her parents slept, Sarah got up. She went to the guest house attached to the family property. A tenant named Mel Spiegel rented the room above the garage. Spiegel was an electrician who was out of town that week. He kept a rifle in his room, .264 caliber weapon, a high-powered hunting rifle of the kind common in Idaho households. Sarah took it. She returned to the main house. Before she went to her parents' bedroom, she made two preparations that would become central to the prosecution's arguments about premeditation. She pulled a shower cap over her blonde hair. Then she put on a pink plush bathrobe and wore it backward so that the front of the robe faced outward behind her. The shower cap and the backward robe were not random choices. Prosecution argued they were a rudimentary attempt to prevent hair and fibre transfer. 16-year-old's understanding of what forensic evidence looked like, and a 16-year-old's attempt to manage it. The door to her parents' bedroom was propped open with pillows. Alan and Diane Johnson did this regularly during warm months because the house's ventilation created a pressure differential that would otherwise slam the interior doors. The open door meant Sarah could walk in without the sound of a latch. Diane Johnson was asleep in the bed. Sarah walked to the bedside and shot her mother in the head at close range. Diane Johnson died where she slept. Alan Johnson was in the shower when the shot was fired. He heard it and came out. He found his wife. He found his daughter. Sarah shot him twice in the chest. He fell. He did not survive. What Sarah did in the minutes after both of her parents were no longer alive is the part of the case that the prosecution used to establish the deliberate architecture of what she had planned. She did not call for help. She did not leave the house. She walked through the rooms and placed knives at the foot of her parents' bed and in her brother's room. The knives were arranged in a way that was meant to suggest gang activity, a staged message that pointed at a different kind of violence from a different kind of person. She returned Mel Spiegel's rifle scope to his room. She left the rest of the weapon at the scene, placed in a way that would be found. Then she walked out of her house and ran to a neighbour's property. She told them an intruder had broken in and shot her parents. She did not know who it was, she said. She had been asleep. She had heard the shots and run. Police arrived at the Johnson home to find a scene that did not match the account of a random intrusion. The door had not been forced. The knives had been placed, not dropped. The rifle was present, but its scope was missing. Detail that pointed immediately to the guest house, where Mel Spiegel's belongings were. Investigators went to the guest house and found the scope on Spiegel's bed. The shower cap was recovered. The bathrobe was recovered. Physical evidence connected Sarah Johnson to the weapon, to the scene, and to the preparations she had made before entering her parents' bedroom. Fingerprints were present in places and patterns that did not support the account of a daughter who had been asleep in her room. The investigation moved quickly. Sarah was arrested and charged with 2 counts of first-degree murder. She was 16 years old at the time of the crime. Blaine County prosecutors made the decision to try her as an adult. The case was moved to Ada County for venue reasons and assigned to Judge Mike Crabtree. The 5-week trial began in the spring of 2005. Sarah was 18 by the time the proceedings got underway. Court TV carried the trial live, and the case drew national attention that had begun when the story first broke in September 2003, and had not dissipated in the intervening years. Combination of elements that made the case compelling to outside observers was not difficult to identify. A beautiful small town, a teenage girl, high-powered rifle. A boyfriend her parents had forbidden, a shower cap and a backward bathrobe as a forensic countermeasure, knives staged around the bodies. The neighbour's door and the story about the intruder. The prosecution's case was built on the physical evidence, the forensic connections between Sarah and the weapon and the scene. The testimony of neighbours who had known the family and who described the friction over Bruno Santos in the months before September 2, and the specific details of how the staging had been done. The defence worked to introduce alternative theories and to challenge the forensic conclusions, but the weight of the physical evidence and the specific details of the shower cap and the backward robe and the placement of the knives have created a picture that the prosecution argued could only have been assembled by someone who had been inside that house and had made deliberate choices about what to leave behind and what to obscure. There was also the matter of Mel Spiegel's rifle. Sarah had taken it from a room that was not hers, from a tenant who was out of town, at a time of morning when she had no ordinary reason to be in that room. The scope had been returned to Spiegel's room. The rest of the rifle had been left at the scene, prosecution argued. The separation of the scope from the weapon was another deliberate act, an attempt to create confusion about the chain of possession and point the initial investigation in a direction that might consume time. It did not consume enough time. The jury deliberated after 5 weeks of testimony and returned its verdict on June 30, 2005. Sarah Marie Johnson was found guilty on both counts of first-degree murder. The courtroom, hard, which had been the subject of national television coverage for more than a month, received the verdict in the way that courtrooms do when something that has been building for a long time finally arrives at its conclusion. Judge Crabtree imposed the sentence. 2 concurrent life terms in prison without the possibility of parole. Additionally, 15-year firearms enhancement was attached to the sentence under Idaho law, reflecting the use of a weapon in the commission of the crime. Sarah Johnson was 18 years old when she was sentenced to spend the rest of her life in an Idaho correctional facility. The legal proceedings did not end with the sentencing. Sarah Johnson pursued post-conviction relief through the Idaho court system across the years followed. Her first direct appeal was dismissed on procedural grounds related to a failure to file a timely notice of appeal deficiency that was later attributed to ineffective assistance of counsel. That procedural issue became the basis for a subsequent petition, and the Idaho courts eventually allowed a belated direct appeal to proceed. The Idaho Supreme Court affirmed the conviction on direct appeal. Further post-conviction petitions followed, including an Eighth Amendment challenge mounted after the United States Supreme Court issued rulings in Millerville, Alabama, and Montgomery, Louisiana, that addressed the constitutionality of mandatory life without parole sentences for juvenile offenders. The Idaho courts reviewed those claims and denied relief. A federal court also conducted an evidentiary hearing on several of the post-conviction claims, including a challenge related to unidentified fingerprints recovered from the scene that investigators had documented but not analysed before the trial. The court denied the petition. As of the last available public record, Sarah Marie Johnson remains incarcerated at the Pocatello Women's Correctional Center in Idaho. Bruno Santos, boyfriend at the center of the motive as the prosecution framed it, was never charged in connection with the killings. No evidence placed him at the scene. The prosecution's theory was not that Santos had participated, but that the relationship specifically Sarah's determination to protect it from her parents' opposition, had been the engine of what she planned and carried out. Santos has not been a public figure in the case. Matthew Johnson was at the University of Idaho when his fiancée called to tell him something had happened at the family home. He drove back to Bellevue to find his parents dead, his sister under investigation, and a house that had become a crime scene. He has not spoken extensively in public about the case in the years since the trial. He was the only member of the immediate family not present in Bellevue on the morning of September 2nd, 2003. The shower cap and the backward bathrobe became in the popular coverage of the case and in the subsequent television programming that revisited it, the details that people remembered. They were such specific, practical, methodical choices for a 16-year-old to make in the dark before walking into her sleeping mother's room with a borrowed rifle. They suggested planning that went beyond a single night's decision. They suggested a period of thinking about what the morning would look like, and what evidence it would leave, and what might be done to manage that evidence. The prosecution did not need to discuss exactly how long Sarah had been planning the killings. The shower cap and the bathrobe were enough to establish that the planning existed, and that it had been specific enough to include forensic countermeasures that a teenager had devised on her own. Diane Johnson was 52 years old. She worked as a tax collector for Blaine County. She was asleep in her bed when her daughter walked in. She did not wake up in time to understand what was happening. Alan Johnson was 46 years old. He heard the shot that took his wife and came out of the shower and was shot twice in the chest by the same person. He was a landscaper whose days were organised around physical labour and visible results. The last thing he saw was his daughter, Sarah Marie Johnson, has been in a correctional facility in Pocatello, Idaho, for more than 20 years. She was 16 years old on September 2nd, 2003. She is in her late 30s now. The post-conviction petitions have been denied. The Idaho Supreme Court has affirmed the conviction. The federal court has reviewed the claims and found no basis for relief. Mel Spiegel's rifle is part of an evidence record in Ada County. The shower cap is in the same record. The bathrobe, the knives that were placed and not dropped, the neighbour whose door Sarah knocked on that morning is the last ordinary moment in this case. She ran to that door with a story about an intruder and a performance of terror, and told whoever answered that something had happened at her house. Then the police came. Then the investigation found the shower cap. Then it found the scope on Spiegel's bed. Then it found the fingerprints and the ballistics and the physical connections between Sarah and every element of what had happened inside the Johnson family home on the morning of September 2, 2003. 2 concurrent life sentences, no possibility of parole, a 15-year firearm enhancement, 5-week trial on national television, a shower cap, a backward bathrobe, a borrowed rifle. Alan and Diane Johnson are buried in Idaho. Their son Matthew has lived the rest of his life in the knowledge of what happened to them and who did it. Their daughter is at Pocatello. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next case crosses the border into Canada and into the youngest entry in this entire video. The girl at the centre of it was 12 years old. She is, to this day, the youngest person in Canadian history ever convicted of multiple murder. The people she arranged to have killed were not just her parents. Her 8-year-old brother was also in the house. Case 5, Jasmine Richardson, April 23, 2006, was a Sunday evening in Medicine Hat, Alberta, a mid-sized city of roughly 60, team of people, sitting in the southeastern corner of the province. where the South Saskatchewan River bends through a landscape of coulees and prairie, stretches flat and wide in every direction. Medicine Hat is the kind of Canadian city that does not make national news often. It has a history rooted in natural gas and agriculture, a downtown that reflects decades of steady, unremarkable growth, kind of community identity built around hockey rinks and church basements, and the assumption that the people living on your street are roughly who they appear to be. The Richardson family lived in a house in a residential neighbourhood in Medicine Hat. Mark Richardson was 42 years old, a man described by people who knew him as warm and involved, the kind of father who showed up. His wife Deborah was 48. By every account, the family operated as a unit, organised around ordinary domestic life. They had 2 children at home. Their youngest was Jacob, 8 years old, a second grader, who, by the accounts of family friends, was a cheerful and energetic child who liked the things that 8-year-old boys tend to like. Their older child was their daughter Jasmine, 12 years old, and in grade 7 at a local middle school. Jasmine sang in a church group. She attended school. She was, on the surface of things, a child doing what children do in a mid-sized Canadian city on a Sunday evening in April. What Mark and Deborah Richardson did not know, or did not know the full extent of, was the relationship their daughter had developed with a 23-year-old man named Jeremy Steinke. Steinke was not a figure who occupied the same world as the Richardson family. He presented himself online under a persona that drew heavily from the imagery of gothic subculture and horror fantasy. He described himself in online forums as a 300-year-old werewolf. He was engaged in communities built around extreme content and violent imagery, was 23 years old, and he was communicating regularly, both online and in person, with a 12-year-old girl. The nature of the relationship, and specifically the question of how it had developed, and how long it had been going on before Mark and Deborah Richardson became aware of it, examined in detail during the subsequent legal proceedings. What became clear was that by early 2006, Jasmine and Steinke had established a relationship that both of them understood to be romantic in nature, and that Jasmine's parents had responded to their awareness of it by attempting to shut it down. Mark and Deborah Richardson told their daughter the relationship was not appropriate. The 23-year-old man had no business being in contact with a 12-year-old girl in the way Steinke had positioned himself. Her parents were clear about that. They set rules. They attempted to restrict contact. They did what parents do when they identify something they believe is dangerous to their child and respond to it with the authority available to them inside the household they run. Jasmine responded by telling Steinke that her parents were the obstacle. The online communications between Jasmine and Steinke in the months before April 2006 were recovered by investigators and became central to both of prosecutions that followed. What those communications showed was not the venting of a frustrated teenager who wished her parents were different. They showed sustained, specific planning. Jasmine and Steinke discussed killing her family in terms that covered method, timing, and what would happen afterward. The discussions were not brief or hypothetical. They went on, across multiple conversations, and covered the logistics of what removing her parents from the situations would require. Jasmine's motivation, as the prosecution presented it to the court, was uncomplicated. Parents were telling her she could not have the relationship she wanted. If her parents were no longer present, that problem would be solved. There was a detail from the investigation that sat with people who followed the case, and that the prosecution used to establish the depth of Jasmine's investment in what she and Steinke were planning. She had, at some point in the weeks or months before April 23, written in online communications that she wanted her family dead. She used specific language. She described what she wanted to happen to each member of her family. These were not passing expressions of adolescent frustration of the kind that parents everywhere recognize and generally discount. They were detailed, they were repeated, and they were addressed to a 23-year-old man who had already indicated he was willing to help make them real. On the evening of April 23, 2006, Jeremy Steinke entered the Richardson family home in Medicine Hat. Mark Richardson was inside. Deborah Richardson was inside. Jacob Richardson, 8 years old, was inside. Jasmine was also in the house when Steinke arrived, though the specific sequence of what happened and where she was during each phase of the events of that evening was subject to legal examination in proceedings that followed. Steinke stabbed Mark Richardson. He stabbed Deborah Richardson. Both died from their injuries inside the family home. He then moved through the house and found Jacob Richardson. The 8-year-old had hidden in his closet. Steinke found him there and stabbed him multiple times. Jacob Richardson died in his closet. All 3 members of the Richardson family, who were home on the evening of April 23, were dead before morning. Jasmine was in the house during the killings and left with Steinke afterward. Police discovered the bodies the following day, after family members were unable to reach the Richardsons and asked for a welfare check. When officers arrived at the house, they found Mark, Deborah, and Jacob Richardson dead from stab wounds. The investigation that followed moved quickly. Once investigators began pulling the digital record, the online communications between Jasmine and Steinke were extensive and were recovered without significant difficulty. Both were arrested. Jasmine was taken into custody in Medicine Hat. Steinke was arrested separately, the legal proceedings divided along the lines established by their respective ages. Jeremy Steinke was 23 years old at the time of the killings and was tried as an adult in Alberta's Court of Queen's Bench. Trial proceeded in 2008. The prosecution presented the physical evidence from the crime scene, the digital communications establishing the planning, and testimony that established his presence in the Richardson home on the night of April 23. The jury convicted Steinke on 3 counts of first-degree murder. In Canada, first-degree murder carries a mandatory life sentence with no possibility of parole for a minimum of 25 years. Steinke received that sentence for each of the 3 counts to be served concurrently, meaning he would not be eligible to apply for parole until he had served at least 25 years. Jasmine Richardson's case was an entirely different legal matter. She was 12 years old at the time of the killings. Under the Youth Criminal Justice Act, Canada's framework for dealing with young offenders, a 12-year-old cannot be tried as an adult regardless of the nature of the offence. The proceedings took place in youth court. Farce. Her identity was protected by a publication ban, as is standard for youth offenders in Canada, and the specific details of the evidence presented against her in the youth proceedings were subject to the same publication restrictions. What became a matter of public record was the verdict and the sentence. Jasmine Richardson was convicted of 3 counts of first-degree murder. At the time of her conviction, she was the youngest person in Canadian history ever to be found guilty of multiple murder. The record was not a distinction that carried any ambiguity. She had been 12 years old when the killings took place. Post. The youth justice system in Canada, no precedent for a case that combined her age with the number and nature of the offences she had been found guilty of committing or arranging. The Youth Criminal Justice Act sets the maximum sentence available for the most serious offences committed by young offenders. For an offender of Jasmine's age convicted of first-degree murder, the maximum custodial term available to the court was 10 years. Court imposed that maximum. She was sentenced to 10 years in youth custody, the harshest penalty the Act permitted for a 12-year-old convicted of the most serious category of offence in the Canadian Criminal Code. The terms of her custody, her placement, and the conditions attached to her eventual release were governed by the Act and subject to ongoing review by youth justice authorities. The publication ban protecting her identity remained in effect. The sentencing prompted public debate in Canada about whether the Youth Criminal Justice Act was adequate to cases of this severity. Legal scholars and victims' advocates and members of the public engaged in a discussion that the Richardson case had forced into the open. 12-year-old, who had arranged the killing of her parents, and her 8-year-old brother had received the maximum sentence the law allowed. That maximum was 10 years. The debate about whether 10 years was a sentence commensurate with 3 murders, regardless of the age of the person responsible, did not produce legislative change in the immediate aftermath of the case. But the Richardson case became one of the reference points in ongoing Canadian discussions about youth criminal justice and the treatment of the most serious juvenile offenders. Jeremy Steinke gave an interview from prison some years after his conviction, in which he claimed that Jasmine had been primary force behind the plan and that he had been manipulated by her into carrying out what she had designed. The interview was reported on in Canadian media and generated its own round of public discussion about how responsibility should be understood in a case where a 23-year-old man had taken direction from a 12-year-old girl. The court had already addressed that question through the verdicts. Both were convicted of first-degree murder. Both bore criminal responsibility for what happened in the Richardson home on April 23, 2006. The interview from prison did not alter those findings. Mark Richardson was 42 years old. He was described by people who knew him as a devoted father who showed up for his family. He died from stab wounds in his own home on a Sunday evening in April. Deborah Richardson was 48 years old. She died in the same house on the same night. Jacob Richardson was 8 years old. He had hidden in his closet. He was found there. He died there. He was in 2nd grade. The gap between what Jacob Richardson was, an 8-year-old boy hiding in his closet on a Sunday night, what the plan his sister had been developing with a 23-year-old man online was designed to produce, is the part of this case that does not resolve into anything comfortable, regardless of how long you sit with it. He was not the primary obstacle. He was simply in the house. And the plan, as Jasmine and Steinke had discussed it across those months of online communication, accounted for everyone who was in the house. Jasmine Richardson served her sentence under the terms of the Youth Criminal Justice Act. The conditions of her release and the details of her life after the custodial period were protected by the publication ban that had applied throughout the proceedings. Her name became publicly known in the years following the case through media reporting that identified her despite the ban, and the case has been the subject of documentary coverage and true crime programming that examine the relationship between her and Steinke and question of how a 12-year-old arrives at the decision she made. Those are questions the court did not need to answer in order to convict her. Evidence of planning was in the communications. The evidence of the outcome was in the house. 3 members of the Richardson family did not survive April 23, 2006. A 4th was not home. The 2 people responsible for their deaths were a 23-year-old man who is serving 3 concurrent life sentences in a Canadian federal penitentiary, girl who was 12 years old. when she decided that her parents' objection to her relationship was a problem that required a permanent solution, and who extended that solution to include her 8-year-old brother because he was also in the house. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next case stays in Canada, but moves west to the city of Mississauga, Ontario, just outside Toronto, where two sisters spent weeks researching methods online before carrying out what the presiding judge described as the strongest prosecution case he had encountered in more than 30 years of prosecuting, defending, and sitting in judgment. The victim was their mother. She was 39 years old. $133,000 life insurance policy she carried was already in their calculations before she died. Case 6, the Bathtub Girls. The murder of Linda Anderson, June 2003. Mississauga, Ontario. A city of nearly 700 people. Sitting along the northwestern shore of Lake Ontario, immediately west of Toronto, connected to the larger metropolitan area by highways that funnel commuter traffic in both directions through the kind of interchangeable suburban landscape that defines the outer edges of every major North American city. Mississauga has subdivisions that run for miles through terrain that was farmland 2 generations ago and is now composed of detached houses on standard lots with attached garages and backyard decks, and the particular anonymity that comes from density without intimacy. Host. It is the kind of place where a family can live for years without their neighbours knowing much about what happens inside their house. Linda Anderson was 39 years old in the summer of 2003. She was a single mother raising 3 children in Mississauga. The 2 older children were daughters. The older girl was 16. Her younger sister was 15. There was also a younger son. Linda's household was not a peaceful one by the accounts that emerged during the subsequent legal proceedings. Daughters described a home environment defined by conflict, dysfunction, and what they characterized as abuse. Older daughter, Sandra, testified that she had attempted to report the conditions of the household to the Children's Aid Society of Ontario and had been told the agency could not intervene based on what she had brought to them. Both daughters described feeling trapped, describing a situation in which the normal avenues available to young people in difficult home situations had been tried and had produced nothing. The defence leaned on this account throughout the proceedings. The picture it painted was of 2 teenagers who had exhausted other options and who had arrived at a terrible decision through a process that included genuine suffering. Prosecution's response was methodical and did not dispute that the household had been difficult. What it disputed was the characterization of the crime as a desperate act. Because the evidence did not support that characterization, the evidence supported something different. It supported the conclusion that what the 2 sisters had done had been researched, planned, prepared over a period of weeks, and that the planning had included not just the method, but also the financial calculation that sat underneath the method. Linda Anderson carried a life insurance policy worth $133,000. Her daughters were aware of the policy. In the weeks before June 2003, both sisters had been conducting internet searches on methods of killing their mother. The searches were not vague. They were targeted and practical, kind of searching that a person does when they have identified a specific problem and are looking for a specific solution. They searched for methods that would work. They searched for methods that could be carried out by 2 people without specialized equipment or knowledge. They read what the internet told them, and they arrived at a method. On the night in question, the 2 sisters held their mother, Linda Anderson's head, underwater in the bathtub of the family home until she was no longer breathing. Linda Anderson was 39 years old. She died in her own bathroom, held down by her two daughters, and the cause of her death was drowning. The medical examiner's findings were unambiguous. The manner of death was homicide. The investigation that followed was not a long one in terms of the time it took to identify suspects. Linda Anderson's death was initially examined as a potential accident or medical event, but the circumstances of the case and the behaviour of the two sisters in the period after their mother's death drew the attention of investigators. The digital record was the fulcrum. The internet search history on the devices available to the sisters documented weeks of research into methods of killing, the communications between them, and between the older sister and her boyfriend, laid out a picture of planning that predated the night Linda Anderson died by a considerable margin. Boyfriend of the older sister had known about the plan. He had been in communication with the sisters about it, through chat logs that were recovered by investigators. He had not been present in the house on the night of the drowning. His knowledge of and participation in the planning of the crime made him criminally liable under Canadian law. He was subsequently charged and convicted of conspiracy to commit murder and of helping cover up the crime after it occurred. Conviction was based substantially on the lot logs between him and the sisters, which documented the planning in considerable detail and established that his awareness of what was being organised had not been passive. The $133 Zealand life insurance payout was processed after Linda Anderson's death. The full amount was paid to the daughters as beneficiaries. By the time the legal proceedings had worked their way through the courts, and the Crown sought to recover the insurance money on the grounds that the beneficiaries had caused the death from which they were profiting, only $48,487 gros forçats remained. The rest had been spent. Whatever was recovered from that remaining amount was directed to the younger brother, third child, who had not been part of what his sisters had planned and carried out. Crown's legal argument rested on the principle that a person cannot benefit financially from a crime they have committed, principle that exists in Canadian law as it does in most common law jurisdictions. That applied with particular directness to a situation in which the beneficiaries of a life insurance policy had deliberately caused the death, triggered the payout. Both sisters were tried and convicted. The proceedings took place under the Youth Criminal Justice Act because both were under 18 at the time of the offence. The specific terms of their sentences and the details of their placements were subject to the publication restrictions that apply to youth justice proceedings in Canada. What entered the public record was the verdict, the judge's remarks at sentencing, Crown's pursuit of the insurance funds. The judge's remarks at sentencing became the most widely quoted element of the case in subsequent years. He said that the evidence against the two sisters was overwhelming. He then said something that went further than the standard language of sentencing remarks. He described it as probably the strongest case he had ever seen in more than 30 years of prosecuting, defending, and sitting in judgment in criminal cases. 30 years of exposure to the full range of what Canadian criminal courts process. And this was the one he held up as the most comprehensively documented and prosecuted case he had encountered. Comment was not hyperbole for effect. It was a judge who had spent 3 decades in courtrooms telling the people in the room what the dentary record looked like from where he was sitting. The strength of the case rested on the layering of the evidence. The internet searches established intent and planning over an extended period. Chat logs established that the planning had been communicated to at least one other person, and had been discussed in terms that went beyond general expressions of frustration. The financial dimension, the life insurance policy, and the awareness both sisters had of its existence and its value established a motive that was concrete and calculable rather than abstract. Physical evidence from the bathroom established the manner of death and was consistent with the method the search history showed. The sisters had researched. The prosecution did not need to construct a circumstantial argument from fragments. The fragments had been assembled for them by the sisters themselves across weeks of searching and communicating on devices that retained everything. Boyfriend's conviction added another layer of corroboration. He had known. He had discussed it. He had not stopped it. Chat logs that established his knowledge also established the reality of the plan in the period before it was carried out, because a plan that has been communicated to a third party in specific terms is not a fantasy. It is a plan. Linda Anderson was 39 years old. She had 3 children. She lived in a house in Mississauga. In the summer of 2003, people who held her underwater in her own bathtub were her 2 daughters. Aged 16 and 15, spent the preceding weeks on the internet, learning the most effective way to do it. The $133.00 from her life insurance policy was paid out after her death. By the time anyone thought to ask where it had gone, most of it had already been spent. The younger brother was a child navigating a household that had been defined by conflict, and that was then defined by the absence of his mother and the arrest of his sisters. He received whatever remained of the insurance money, after the Crown recovered what it could. He was not old enough when any of this happened to have had a meaningful say in anything that occurred around him. He is the part of this case that the headlines and the judge's remarkable sentencing remarks and the discussion of internet search histories and insurance policies tend to obscure. There was a third child. He lost his mother. His sisters killed her. For reasons that included a financial calculation he had no part in. The case became known in Canadian true crime coverage and in international reporting as the Bathtub Girls case, a label attached to it by media coverage in the years following the conviction. The label did what labels in true crime coverage tend to do, compressed a set of facts that were considerably more layered than any shorthand could capture into a phrase that was easy to reference and easy to search. Behind that phrase was a 39-year-old woman who died in her bathroom, an insurance policy that had already been factored into the planning before she died. Weeks of online research into drowning methods, chat logs, that a judge described as part of the strongest prosecution case he had seen in 30 years, and a younger brother who received what was left of the payout. Both sisters have since been released from custody, having served the terms imposed under the Youth Criminal Justice Act. Their identities remain protected under the publication ban that applied to the proceedings. They have not been subjects of public reporting in the years since their release, in the way that adult offenders in comparable cases tend to be, because the legal protections that applied during the proceedings continued to apply afterward. Linda Anderson does not have those protections. She has a name that appears in court records and media coverage and true crime databases, and a grave somewhere in Ontario. She was 39 years old. The insurance money is gone. The brother has whatever the courts managed to recover for him. The judge's 30 years of courtroom experience produced one case he held above all others as the strongest he had seen. This was it. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next case moves from the suburbs of Toronto to the streets of Compton, California, where a 15-year-old girl and her 16-year-old boyfriend killed her mother and stepfather inside their family home, drove both bodies to separate locations across Los Angeles County, buried them in the ground, and then went shopping for party supplies, with one of the bodies still in the car. Case 7. Cynthia Alvarez. Sometime between the evening of October 13 and the morning of October 19, 2011, 2 people were killed inside a house in Compton, California. Their bodies were not found in the house. They were found days later in shallow graves at 2 separate locations across Los Angeles County, one in a vacant lot on Atlantic Avenue in North Long Beach, approximately a block from the family home, and one in Norwalk, several miles to the east. The 2 people were Gloria Villalta, 58 years old, and Jose Lara, 51 years old. They were a mother and stepfather, daughter and stepdaughter, who lived with them in the Compton house, was 15 years old. Her name was Cynthia Alvarez. Gloria Villalta had spent decades building the kind of life that immigrant families in Los Angeles construct through sustained physical labor and the accumulation of small stabilities. She was 58 years old in the fall of 2011, a woman who had raised her daughter in Compton through whatever combination of circumstances and decisions had brought them to that house, on that street. Jose Lara was her partner, 51 years old, a man who had become part of the household, and who, by the accounts available in the public record, had been present in Cynthia's life as a stepfather figure for a meaningful period of time. The family occupied a house in a part of Compton that sits close to the border with North Long Beach, neighborhood where the streets are dense with residential housing, and the pace of life is organized around work schedules and school calendars, and the ordinary logistics of keeping a household running. Cynthia Alvarez was 15 years old in October 2011 and involved with a 16-year-old boy named Giovanni Gallardo. The relationship had produced friction inside the Villalta household. Gloria and Jose had expressed opposition to the relationship in terms that Cynthia understood clearly, the specific nature of their objections, and the specific conversations that had occurred between Cynthia and her parents about Giovanni Gallardo were not laid out in granular detail in the public court record. But what the Los Angeles County District Attorney's Office established was that the opposition to the relationship had been real, sustained, and understood by Cynthia as an obstacle she needed to remove. The removal she and Giovanni settled on was not a negotiation or an attempt to find accommodation. It was what the charge sheets described as murder, carried out inside the family home, with both bodies subsequently transported and buried at separate locations across the county. The sequence of events, reconstructed by investigators, began with Gloria Villalta. She came home from work at some point during the window the prosecution established between October 13 and October 19. She was killed first, inside the house before Jose Lara returned. Her body was hidden. Jose Lara arrived home later. Prosecution's account of what happened when he came through the door was presented to the jury in the terms established by the physical evidence testimony available to the state. He was beaten with a baseball bat. He was stabbed. He died inside the house from the injuries he sustained. The 2 teenagers then faced the practical problem of 2 bodies in a residential house in Compton and arrived at a solution that involved loading the remains into a vehicle and driving them to separate locations for burial. Detail that the prosecution introduced about what happened between the killings and the discovery of the bodies is the one that attached itself durably to the case in subsequent reporting and public discussion. At some point during the period after Gloria Villalta and Jose Lara were dead, before their remains were deposited at the burial sites, Cynthia and Giovanni went shopping for party supplies. One of the bodies was in the trunk of the family car. During at least part of that interval, Deputy District Attorney Kristin Trutanek addressed the jury directly about this in her closing argument. She said it was absolutely disturbing what Cynthia had done to her parents, the way she let them die and then rot, one in the car and one in the ground. The framing was deliberate. The prosecution wanted the jury to understand not just the mechanics of the crime, but the texture of what had followed it. The ordinariness of a shopping trip, conducted in proximity to what had just been done. Gloria Villalta's body was discovered on October 19. Jose Lara's body was found in North Long Beach not long after. The investigation moved from the discovery of the remains backward toward the house in Compton and forward toward the two teenagers who had been living in it. Cynthia Alvarez and Giovanni Gallardo were identified as suspects and arrested. Both were 15 and 16 years old, respectively. The Los Angeles County District Attorney's Office made the determination to charge both as adults. Charges against Cynthia were serious in their construction. 2 counts of murder formed the core of the case. Attached to each count were special circumstance allegations. Lying in wait and multiple murders. The lying in wait allegation addressed the specific manner in which Gloria Villalta had been killed, prosecution's position being that she had been ambushed inside her own home by people she had no reason to suspect. Multiple murder allegation addressed the fact that 2 people had been killed rather than one. Praspas. Both special circumstances were legally significant because they elevated the severity of the case beyond standard first-degree murder in California sentencing framework. Because of Cynthia's age, she was not eligible for the death penalty, but the special circumstances meant the potential consequences of conviction were the most serious available under California law for a juvenile defendant. The trial proceeded in Los Angeles County Superior Court. The prosecution's case rested on the physical evidence from the crime scene and burial sites. The forensic connections between the defendants and the victims, and the testimony of witnesses who could speak to the relationship dynamics inside the Villalta household, and to the events of the period between October 13 and October 19. Trutanek's presentation to the jury was built on the totality of the evidence and on the behavioural record of what Cynthia and Giovanni had done in the days after the killings. The defence offered a counter-narrative that addressed Cynthia's culpability through the lens of her age, her psychological state, and the influence she argued Giovanni Gallardo had exercised over her. Cynthia's defence attorney, Carol Telfer, told the jury that Cynthia needed to be saved, and argued that the prosecution was effectively trying Giovanni's case in Cynthia's courtroom. The argument was that Cynthia could not have planned or carried out such a crime independently, that whatever she had been done under the direction and pressure of her older boyfriend, and that her own agency in the events of that week was more limited than the prosecution's framing suggested. Cynthia herself testified. She acknowledged on the stand that she had struck her stepfather, Jose Lara, with a baseball bat. Her account of why she had done so was that she feared Giovanni would hurt her if she did not comply with what he demanded. The testimony placed her inside the house at the time of at least one of the killings, and acknowledged her physical participation in the violence that produced Jose Lara's death, while arguing that her participation had been coerced rather than chosen. Prosecution pushed back on that framing with the evidence of the shopping trip, with the burial logistics that required active participation from both people involved, and with the overall behavioural record of the period after the killings that did not suggest a person operating under duress so much as a person managing a situation she was invested in managing. The jury deliberated and returned its verdict. Cynthia Alvarez was convicted on both counts of murder. The special circumstance findings were upheld. She was sentenced to life in prison. Giovanni Gallardo's case proceeded separately through the adult court system. He faced the same charges and the same potential consequences under California law. His trial and sentencing were adjudicated on a timeline. Separate from Cynthia's, the outcomes of his proceedings were reported in Los Angeles County court records. Gloria Villalta was 58 years old. She had spent decades building a life in Compton. She came home from work and was killed before she had time to understand what was waiting for her inside her own house. Jose Lara was 51 years old. He came home after she did. He came through the front door and was beaten with a baseball bat and stabbed. Both of them were then driven across Los Angeles County and buried in the ground at locations chosen for their convenience as disposal sites rather than for any other reason. The vacant lot on Atlantic Avenue in North Long Beach was approximately a block from the house where they had lived. Distance between where Gloria Villalta's body was found and where she had been killed was a matter of a few hundred yards. The shopping trip for party supplies is the detail that the prosecution understood would do the most work with the jury. Prosecution was right about that. It is not the worst thing in this case, in any clinical or legal sense. The worst things happened inside the house on the days between October 13 and October 19. But the shopping trip is the image that persists because it captures something about the emotional register in which the events following the killings were conducted. Two teenagers drove to a store and bought party supplies, while one of the people they had killed was in the trunk of the car. Practical mind that organized the burial logistics and the practical mind that decided to go shopping were the same mind operating on the same afternoon in the same vehicle. Cynthia Alvarez has been in a California correctional facility since her conviction. She was 15 years old when Gloria Villalta and Jose Lara died in their Compton house. She acknowledged on the stand that she had hit her stepfather with a baseball bat. She was convicted of 2 counts of murder with special circumstances and sentenced to life in prison. Giovanni Gallardo was 16 years old. Both were charged as adults. Both were convicted. The house in Compton where the killings took place sits in a neighborhood where houses like it line streets like that one across several square miles of the southern Los Angeles basin. Gloria Villalta had lived in it. Jose Lara had lived in it. It was their home. The daughter who had grown up in it had decided the people who ran it needed to go, and she had found someone who agreed with her. The two of them had done what they had agreed to do. Then driven the evidence to 2 different holes in the ground and gone shopping. Gloria Villalta was 58 years old. Jose Lara was 51 years old. Their daughter is serving life in a California prison. The vacant lot on Atlantic Avenue, where one of them was found, is still there. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next case crosses the Pacific to the suburbs north of Toronto, where a young woman had spent nearly a decade constructing an elaborate fiction about her own life. University degrees she had never earned, nursing programs she had never attended, a career she had invented from scratch and maintained through forged documents and careful management of what her parents were allowed to see. When the fiction finally collapsed, she picked up the phone and made a call that would take 4 years to reach a verdict and another decade of appeals to partially unwind. Case 8, Jennifer Pan, November 8, 2010, was a Monday evening in Markham, Ontario, a suburban city of roughly 300,000 people, sitting approximately 30 kilometers north of downtown Toronto. in the upper reaches of the Greater Toronto Area. Markham is one of the most ethnically diverse municipalities in Canada, a city built in significant part by waves of immigration from Hong Kong, mainland China, and Southeast Asia across the 1980s and 1990s. Families who arrived with professional credentials or trade skills, or simply with the willingness to work at whatever the new country required, and who built their households around the specific set of values that immigration tends to concentrate. Education as the non-negotiable foundation, professional achievement as the validation of sacrifice, and the success of the children as the return on everything the parents had given up to be here. The Pan family lived on Crippen Court in Markham in a detached house in a quiet residential subdivision that reflected exactly the life Hue Han Pan and his wife Bich Ha Pan had worked to build. Han Pan, as he was known, had immigrated to Canada from Vietnam. He and Bich Ha had come with very little and had spent the decades of their working constructing stability from the ground. Up, Han worked, Bich Ha worked. They owned their home. They had raised 2 children, and they had done what immigrant parents who have sacrificed a great deal for their children's futures tend to do, with the specific intensity that comes from knowing exactly what the alternative looks like. They had held their children to a standard that reflected everything the sacrifice had been for. Their daughter was Jennifer Pan, born in 1986, the older of their 2 children. Jennifer had, by the account her parents carried into November 2010, been a remarkable young woman. She had studied piano with dedication, serious enough to produce competition results. She had been a promising figure skater in her youth. She had graduated from high school, enrolled at Ryerson University in Toronto, and gone on to study nursing. She was, in the picture her parents held, return on the investment. She was exactly what the sacrifice had been for. She was not any of those things. The reality that investigators began uncovering in the hours and days after the events of November 8, 2010, was that Jennifer Pan had been constructing a parallel identity for nearly a decade, a fabricated version of her own life, maintained through documents she had forged, and a performance she had sustained across years of family dinners, conversations, and parental expectations that she had learned to satisfy with paper, that did not reflect anything real. She had not graduated from high school in the conventional sense. She had failed a credit required for her diploma and had forged the documentation to conceal the failure. She had enrolled briefly at Ryerson University, attended for a short period, failed her courses, then simply continued, going through the motions of being a university student, leaving the house each day and returning each evening with the behaviour of a person whose enrolment was ongoing when it had in fact been terminated. She forged transcripts, she fabricated the nursing program, she constructed, with considerable sustained effort, and a detailed understanding of what her parents expected to see, an entire educational biography that did not exist. Beneath the fabricated biography was a relationship her parents had also forbidden. Daniel Wong had been Jennifer's boyfriend for 7 years. He was not a figure who fit the template of the future her parents had envisioned for her. When Anne and Bikar had become aware of the relationship, they had responded in the way the household's operating principles demanded. Relationship was not acceptable. It needed to end. Jennifer's response to that directive had been to maintain the relationships in secret while maintaining the fiction of the life her parents believed she was living. A double concealment that she had sustained for years. In 2010, the structure collapsed. Han and Bich Ha discovered that the educational record they had been shown and told about, and held up as evidence of their daughter's progress, did not exist. The degree was not real. The nursing program was not real. Years of the story Jennifer had built for them came apart at once. The response from her parents was to pull her back inside the household under a set of strict rules designed to impose the kind of supervision that they now understood they had failed to maintain. Jennifer was required to be home. The relationship with Daniel Wong was again explicitly forbidden. She was told she needed to begin again, from the beginning, under conditions that her parents controlled. Jennifer Pan was 24 years old when the fiction collapsed. She had spent the better part of a decade maintaining it. The prospect of beginning again under parental supervision, the relationship her parents had forbidden removed, was the situation she was looking at in the months leading up to November 8, 2010. What she did about that situation was contact Daniel Wong and tell him she needed her parents to be gone. Wong had connections to people willing to carry out the kind of work Jennifer was describing. The arrangement that came together through those connections involved 3 men. The agreed payment structure, as prosecutors established it at trial, approximately $10,000, allocated on a per-parent basis. The men were Lenford Crawford and David Milvaganam, who would enter the house, third connected to the network. A 5th individual named Eric Carty was also involved in the planning and was tried separately. Plan was designed to look like a home invasion, a robbery gone wrong, the kind of thing that could happen to anyone in a suburban house on a Monday evening. On November 8, 2010, Jennifer called 911 from the family home on Crippen Court. She reported a home invasion. 3 men had broken in, she said. They had tied her parents up. They had shot them. She had been spared because she had begged them not to hurt her. Han Pan had been shot in the face. The bullet entered near his eye and travelled through his head. He was in critical condition and placed in a medically induced coma. He survived. The recovery from a gunshot wound of that severity was prolonged and its effects lasting. Bitch Ha Pan had also been shot. She was 55 years old. She did not survive. She died in the house on Crippen Court on the evening of November 8, 2010, in a home invasion that her daughter had arranged and paid for. When police arrived, they found Jennifer in the house with her hands tied. She told them the story she had prepared. She had been restrained, she said. The men had left her alive. She described what had happened in the language of a witness, a survivor, daughter, who had been present when something terrible occurred to her parents. The investigators who interviewed her that night were not convinced. The 911 call did not have the quality of genuine terror, in the way that 911 calls from people experiencing real emergencies tend to sound. The scene had elements that did not align with the account of a random robbery. The questions the investigators asked in the initial interviews produced answers that generated more questions. The investigation that followed was patient and methodical. York Regional Police built the case over the months after November 8th through phone, records, communications analysis, and the network of connections between Jennifer and Daniel Wong and the men Wong had recruited. The calls between Jennifer and Wong in the period leading up to the shooting were documented. The communications within the group that had organised the plan were traced. In the spring of 2011, Jennifer Pan, Daniel Wong, Lenford Crawford, David Milvaganam were all arrested. Eric Carty was arrested separately and faced a separate trial. The trial that followed was one of the longest and most closely watched on criminal proceedings in Ontario in recent memory. It ran for 10 months in Newmarket, Ontario, the seat of York Region's court system. The jury heard from investigators who had built the communications case against the 4 defendants. They heard the 911 call Jennifer had made from the house on the night of November 8. They heard testimony about the financial arrangement that had been made with the men who had entered the house. They heard about the forged documents and the fabricated biography and the years Jennifer had spent maintaining a fiction about who she was and what she had accomplished. They heard Daniel Wong's account of how the plan had come together. 10-month trial produced an evidentiary record of considerable depth and a jury that deliberated for 4 days before returning its verdicts. On December 13, 2014, Jennifer Pan, Daniel Wong, Lenford Crawford, and David Milvaganam were all found guilty of first-degree murder and attempted murder. Jennifer dropped her head when the verdict was read. She then sobbed as the judge confirmed the sentencing date. In Canada, conviction for first-degree murder carries an automatic life sentence with no possibility of parole for a minimum of 25 years. Jennifer Pan was sentenced to life in prison with no parole eligibility for 25 years for the first-degree murder of her mother. She received a concurrent life sentence for the attempted murder of her father. Wong, Crawford, and Milvaganam received the same sentences. Eric Carty, tried separately, was convicted of conspiracy to commit murder and sentenced to 18 years in prison. The case became the subject of a Netflix documentary titled What Jennifer Did, released in April 2024, which examined the case through interviews with the investigators who had built it, and through the documentary record of the police interrogations Jennifer had undergone in the days after November 8. The documentary reached the top of Netflix's viewing charts in multiple countries in the days after its release, and introduced the case to an international audience that had not followed the original proceedings. The legal proceedings did not end with the 2015 sentencing. Jennifer and her co-accused appealed their first-degree murder convictions. In May 2023, the Ontario Court of Appeal ordered new first-degree murder trials for all 4 defendants, on the grounds that the original trial judge had made a critical error in instructing the jury. The judge had directed the jury to consider only first-degree murder rather than also presenting the options second-degree murder and manslaughter as findings available on the evidence. The Court of Appeal found that this instruction had been incorrect and that it had potentially foreclosed findings that the jury might otherwise have reached. The attempted murder convictions which related to Han Pan's survival were affirmed and were not subject to the new trial order. In April 2025, the Supreme Court of Canada reviewed the appeal and confirmed the Ontario Court of Appeal's order. New first-degree murder trials were directed. The legal proceedings were active and ongoing as of the time of this video. Jennifer Pan remained incarcerated during the appeal process. The murder conviction that had been entered in December 2014 had been set aside on the technical grounds identified by the appellate courts. But she remained in custody pending the resolution of the retrial process. Han Pan survived the gunshot wound to his face and head. He recovered over a prolonged period. He testified during the original trial, giving evidence about his daughter, about the night of November 8, and about the family he had built over decades of work and sacrifice. He described the household, the rules, the expectations, and the relationship between Jennifer and her parents, in terms that filled in the background a case that had already generated enormous public interest. He is alive today. He lost his wife of decades in a home invasion his daughter had paid for. He testified against his daughter in a courtroom in Newmarket, Ontario. He survived a bullet that had been intended to kill him. Bitch Harpan was 55 years old. She had immigrated to Canada from Vietnam with her husband and had spent the decades of her adult life building the household on Crippen Court and raising 2 children and working toward the future that immigration had made possible. She died on a Monday evening in November 2010 in her own home, shot by men her daughter had hired for approximately $10,000. The nursing career that Jennifer had fabricated, the university transcripts that did not exist, the piano competitions, the figure skating, the high school diploma, the story of a daughter who had returned on every investment her parents had made. None of it was real. Bitch Harpan was real. The bullet was real. The house on Crippen Court was real. Jennifer Pan is in a Canadian correctional facility. The Supreme Court has ordered a new trial on the first-degree murder conviction. The attempted murder conviction stands. Han Pan is alive. The house on Crippen Court is still there. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next case takes us back across the border to upstate New York, where a 20-year-old college student drove her father to her mother's house on a winter evening in 2017, walked inside, kept her younger sibling occupied in another room, and waited while her father strangled her mother to death. What she told police afterward was a lie she had been coached to tell. What the investigators found when they looked more carefully was the truth. Case 9. Carrie Neurotta. The city of Corning sits in Steuben County in the southern tier of New York State, region of small post-industrial cities and rural towns arranged along river valleys in the southwestern corner of the state, where the terrain rolls into the foothills of the Appalachians, and the economic history of the area is written in the architecture of factory buildings that no longer produce what they were built to produce. Corning is best known outside the region as the home of Corning Incorporated, the glass and materials science company that has operated there since the 19th century, and that remains the dominant employer in a city of roughly 10,000 people. It is the kind of place where families have roots that go back several generations, and where the dissolution of a marriage and the financial consequences of that dissolution are not abstract matters, but practical ones that shape the daily texture of people's lives in ways that are difficult to overstate. The Neurotta family had come apart through divorce. Lloyd Neurotta and his wife, Dawn, had ended their marriage, and the terms of that ending had produced the financial obligations that divorce in New York State produces when there are children and a disparity in circumstances between the two parties. Lloyd was required to pay child support, required to pay alimony. He retained some form of custody arrangement connected to the youngest child, who continued to live with Dawn. Financial obligations were ongoing, and by Lloyd's account, and by the account his daughter Carrie would later give in court, food. They had become a source of pressure that Lloyd described in the most extreme terms available to him. Carrie Neurotta was 20 years old in 2017 and attending college in upstate New York. She was Lloyd and Dawn's daughter, young woman in the early stages of an adult life, navigating the particular complexity of being the child of a broken marriage in which both parents remained present, and in which the financial and emotional residue of the divorce had not settled into anything stable. Lloyd had maintained a relationship with Carrie throughout the post-divorce period, and it was through that relationship that he brought her into what he was planning, or what he claimed to have been driven to consider. The account Carrie gave in court, and the account that shaped the plea agreement she eventually entered, that Lloyd had told her he could not continue. The financial obligations, the child support, the alimony, the ongoing cost of a divorce that had not released him from its consequences, had become unbearable to him, he said. He told his daughter that he was going to end his own life if something did not change. He framed the situation as binary, help him find another solution or lose him. The other solution he had in mind was Dawn Neurotta. If Dawn were no longer alive, child support would end. The alimony would end. The custody arrangement would resolve in a different direction. Financial obligations that he described as unsustainable would dissolve. What Carrie agreed to do, under the circumstances she described, and the pressure she said her father had placed on her, was this. She drove Lloyd to Dawn's home in Corning. She went inside with him. Once inside, she engaged the attention of the youngest sibling, the child who was living with Dawn, keeping that child occupied in another part of the house, in another room, away from what was happening elsewhere in the home. While Carrie kept the child's attention in one direction, Lloyd Neurotta went to where Dawn was and strangled her to death. Dawn Neurotta died in her own home, with her youngest child in the next room, and her oldest child keeping that youngest child from seeing what was happening. When it was over, Carrie and Lloyd worked together to alter the scene. The goal was to make Dawn's death appear to be a suicide. They moved things. They arranged things. They made the physical environment of the room consistent, or as consistent as they could make it, with the presentation of a woman who had taken her own life rather than a woman who had been strangled by her former husband, while her daughter managed the youngest child in the next room. When investigators arrived, Carrie spoke to them and provided the account she and her father had constructed. It was a lie built to serve the staging, and it described a version of events that did not include Lloyd Neurotta's hands around Dawn's throat or Carrie's role in enabling the access that made it possible. The staging did not hold. Investigators examining Dawn Neurotta's death found the physical evidence inconsistent with the manner death presented by the scene. The medical examiner's findings established that the cause of death was not consistent with suicide. The manner of death was homicide. Investigators began looking at the circumstances of Dawn's life, her relationships, the financial structure of the post-divorce arrangement, and the people who had been in contact with her in the period before her death. The investigation moved toward Lloyd Neurotta and, through Lloyd, toward Carrie. Lloyd Neurotta was charged with first-degree murder for the killing of his former wife. The case against him rested on the physical evidence, medical examiner's findings, a financial motive established through the divorce records, and the ongoing support obligations, Carrie's eventual cooperation with the prosecution. Carrie had been charged with second-degree murder for her role in the crime. The distinction between the charges as against Lloyd and those against Carrie, reflected the legal between the person who had carried out the killing and the person who had facilitated it, who had driven the car, who had managed the child, who had helped stage the scene, and who had lied to investigators in the initial interviews. Carrie negotiated a plea agreement with Steuben County prosecutors. Under the terms of that agreement, she would plead guilty to second-degree murder and would testify against her father in the proceedings against him. The recommended sentence attached to the plea was 15 years to life in prison. On March 7, 2018, Carrie Neurotta appeared in Steuben County Court and entered her guilty plea. She was 21 years old. The courtroom was not large. Steuben County is not a place that generates the kind of national media attention that attaches to cases in major metropolitan areas, and the Neurotta case, despite its specific gravity, did not become a story that travelled far beyond the regional news outlets that covered the southern tier. The recommended sentence of 15 years to life was imposed. Carrie Neurotta began serving that sentence in a New York State correctional facility. Lloyd Neurotta was subsequently tried and convicted of first-degree murder for the killing of Dawn Neurotta. His sentence was substantially longer than his daughter's, reflecting the difference between the person who had carried out the killing and the person who had been recruited and pressured into facilitating it. The pressure argument is the part of this case that requires the most careful attention, because it is the part that distinguishes it from the other cases in this video, and that the court had to weigh against the facts of what Carrie had actually done. She had not planned the killing. She had not identified her mother as a target for financial or personal reasons of her own. She had not recruited accomplices or researched methods or drawn up a budget. She had received a phone call or a series of conversations from a father who told her that his life was unsustainable and that the solution to its unsustainability required her mother's death and her participation in making that death happen. She had said yes. She had driven the car. She had walked into the house. She had taken the youngest child into another room and kept that child's attention, pointed away from what was happening on the other side of the wall. She had helped rearrange the scene. She had lied to investigators. The court did not find that the pressure Lloyd had described, the claim that he would take his own life if she did not help him, constituted a defense to the charge. It acknowledged the circumstances as context, did not treat them as an excuse. The guilty plea to second-degree murder and the sentence of 15 years to life were the legal system's accounting what Carrie had contributed to her mother's death. Regardless of the pressure under which she had made those contributions, Dawn Neurota's youngest child was in the house when Dawn was killed. That child had been kept in a separate room by their older sister. The specific experience of that child, on the evening Lloyd Neurota strangled their mother, kept away from the room where it was happening by the sibling who was supposed to be a protective presence, is not something the court record quantifies. It is something that exists in the background of the case, in the way that the experiences of children present during violent crimes exist in the backgrounds of the cases that generated those crimes, present but not fully visible in the public documentation. Dawn Neurota was a mother. She had a youngest child living with her. She had an oldest child who drove her former husband to the house and managed that youngest child while the former husband killed her. She had built a post-divorce life in Corning that included ongoing financial support from a man who had decided that paying that support was more than he was willing to continue doing. And the role he assigned his daughter in carrying it out ended Dawn Neurota's life in her own home in 2017 and put his daughter in a New York state prison for a minimum of 15 years. Lloyd Neurota is serving a sentence for first-degree murder. Carrie Neurota is serving 15 years to life for second-degree murder. The youngest child in the house that evening grew up without a mother. The case is in the Steuben County Court record. It did not make national news. It happened in a small city in upstate New York in 2017, and the people it happened to were ordinary people navigating the ordinary wreckage of a marriage that had ended, and the financial obligations that the ending had produced, until the point at which one of those people decided that the obligations could be ended a different way, recruited his daughter to help him do it. Dawn Neurota was the person in the next room. Her youngest child was with Carrie. Former husband was with her. She was 15 years to life, away from the day she would have seen her oldest daughter again, under circumstances that did not involve a courtroom, and she never got there because she was already gone before the staging had been completed and the investigators had called, and the lie had been told, and the plea agreement had been negotiated, and the sentence had been imposed, and the prison door had closed. We move on. If you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The final case in this video takes us to a small town in East Texas called Alba. where a 16-year-old girl sat in a car outside her family home on the night of March 1, 2008, and made 6 phone calls between 11:46 in the evening and 12:48 in the morning to the 2 men who were inside the house killing her mother, her 13-year-old brother, and her 8-year-old brother who had hidden in his closet. Her father was shot 5 times and crawled 300 yards through East Texas woods in the dark to reach a neighbor's house. He survived. The first thing he asked about when police spoke to him in the hospital was whether his daughter was okay. Case 10, Erin Caffey. The 6 phone calls are the detail that the prosecution returned to most consistently across the legal proceedings that followed March 1, 2008, and they are the detail that has stayed with people who followed the case in the years since. Not the weapon, not the fire, not even the image of Terry Caffey crawling through 300 yards of East Texas woods with 5 bullet wounds. The 6 phone calls, placed between 11:46 in the evening and 12:48 in the morning, from a car parked on the road outside the house to a man who was inside killing her family. 6 calls across 1 hour and 2 minutes. The lead prosecutor said that when she saw the phone records, she knew the case was won. Said she could have prosecuted Erin Caffey without a single co-defendant taking the stand because the records were that clear and that complete. 16-year-old girl sitting in a car in the dark in East Texas, making 6 phone calls to the men she had recruited and paid and briefed and sent into parents' house. What those calls represented, beyond their evidentiary weight, was something about the nature of what Erin had organised and her relationship to it as it unfolded. She was not at a distance from what was happening. She was not somewhere else, having set the plan in motion, and then removed herself from its execution in a way that allowed her to claim separation from the outcome. She was on the road outside. She was in the car. She was calling. 6 times across 1 hour and 2 minutes, she picked up the phone and dialed the number of the man who was inside with the pistol and the sword. The prosecution did not need to speculate about her state of mind during those calls. The calls themselves were the state of mind. The community response in Alba and the surrounding area of Wood County, in the immediate aftermath of March 1, 2008, was what community responses to this category of event tend to be in small towns where the victims are known and the family is embedded in a religious institution that touched a significant portion of the population. The Caffey family had been visible. Terry was a youth pastor. Church had been a centre of the family's public life. The congregation knew the children. People in Alba had watched Erin grow up. They had heard her sing. The news that she had organised the killing of her mother and her 2 brothers while her father survived crawling through the woods ran through the community with the particular force of a revelation that dismantles a shared assumption about a person everyone thought they knew. The church held services. The community gathered in the way that communities gather around grief that is also incomprehension. Terry Caffey was in a hospital. His wife was gone. His sons were gone. His daughter was in custody. The house had burned. There was nothing left of the physical structure of the life the Caffey family had been living on the evening of February 29, when the last ordinary day ended, and the planning that had been accumulating across the preceding weeks moved into its final phase. The question of why is the question that true crime coverage of this case has returned to repeatedly across the years since 2008, and it is a question that the court record does not fully answer, because the court record was not designed to answer it. Court record was designed to establish what happened, who was responsible, and what the legal consequences of that responsibility were. It established all 3 of those things with considerable completeness. What it did not establish, because it was not required to, was a psychological account of how a 16-year-old girl from a stable religious household in a small Texas town arrives at the decision to have her mother nearly decapitated and her 8-year-old brother stabbed in a closet because her parents told her she could not date an 18-year-old. The psychological evaluation that the court ordered found no abuse. It found no trauma history, found no clinical basis for understanding the planning as the product of a household that had damaged Erin in ways that made violence the only exit she could perceive. What it found was a teenager in a stable household who had made a decision and had pursued it across weeks of planning and communication and recruitment. The absence of abuse in the record is significant not because it makes the case more sensational, but because it removes the framework that people most commonly reach for when trying to understand how a child arrives at this kind of violence. Without that framework, what remains is harder to process and harder to file away under a category that makes it comprehensible. Terry Caffey's decision to pursue forgiveness is the element of this case that resists the expectations that the rest of the case sets up. Man who lost his wife and both of his sons on a single night, who survived 5 gunshot wounds by crawling through the woods to a neighbour's house, asked first in the hospital whether his daughter was safe, who then learned that she had organised everything, who then chose, the years that followed, to describe a process of arriving at forgiveness and to maintain contact with her during her incarceration, not behaving in a way that the case itself prepares you for. It is a response that exists entirely outside the logic of the planning and the phone calls and the fire and the closet. It belongs to a different register of human experience from the one that produced the events of March 1, 2008. And the fact that both registers are present in the same story, connected by the same family, is the thing about this case that does not resolve. Erin Caffey pleaded guilty. She received 2 life sentences plus 25 years. She must serve a minimum of 40 years before she is eligible to apply for parole. She was 16 years old on March 1, 2008. She is in her early 30s now. She has been incarcerated for more than 16 years. She will be in her mid-50s before the parole board considers her application. If she applies, if the application is considered, if the board decides the minimum term has produced whatever the minimum term is designed to produce. Charlie Wilkinson and Charles Wade are serving life without parole. Bobby Johnson, who waited in the car and did not enter the house, serving 40 years. The former boyfriend who was approached before Charlie, and who said no, has lived the years since March 2008, with the knowledge that he was asked first and declined, and that declining did not stop what happened, only delayed it until a different person said yes. Penny Caffey was 38 years old. She had built her life around her family and her faith, and the community of a small Texas church where her husband guided young people, and where she sang, and where her daughter sang with such passion that she sometimes wept. She died from gunshot wounds and sword injuries in her bedroom in the early hours of March 1, 2008. Matthew Caffey was 13 years old. He was shot. Tyler Caffey was 8 years old, and he had gone to his closet because something was happening in the house, and he was 8 years old, and the closet was where he went, and Charles Wade found him there. Tyler Caffey was stabbed multiple times in a closet in which he had hidden, and he was 8 years old, and he did not survive. Terry Caffey crawled 300 yards through East Texas pine forest in the dark, with 5 bullet wounds, and reached a neighbor's house, pounded on the door, and collapsed and survived, and woke up in a hospital and asked whether his daughter was okay. She was. she was in a car on the road outside. She had made 6 phone calls. If you enjoyed this breakdown, make sure to subscribe. Thanks for watching, and I'll see you in the next one.